To make my review process easier, I recorded the cases where the chairperson for the 2026 bar examinations, Supreme Court Associate Justice Samuel H. Gaerlan, served as the ponente. This allows me to better absorb the material through listening and reviewing at my own pace. This is the case of Rural Bank of Candelaria Zambales Incorporated versus Banluta Jr. et al. Juror number 208254, March 23, 2022. Ponente Gaerlan J. Facts of the case. Romulo Banluta and his wife obtained a loan from the Rural Bank of Candelaria Zambales Incorporated, secured by a real estate mortgage over two parcels of land. Banluta claimed to have fully paid the loan, but the bank initiated foreclosure proceedings without proper notice. The bank asserted that the loan was not fully paid and that the payments made were for loan renewals, not for full settlement. The bank proceeded with the foreclosure and public auction of the mortgaged properties. Banluta filed a complaint for annulment of the foreclosure, notice of sale, and sheriff's certificate of sale with a prayer for injunction, accounting, recovery of possession, and damages. The RTC declared the auction sale and foreclosure proceedings null and void, ordered reconveyance of the property to Banluta, and required Banluta to pay the bank the principal loan plus 20% interest as stipulated in the promissory note PN dated September 15, 1999. Both parties appealed. The CA affirmed the RTC's nullification of the foreclosure, but upon Banluta's motion for partial consideration, deleted the order requiring Banluta to pay the loan, holding that the PN was materially altered and thus had no evidentiary value. Issues 1. Whether the CA erred in affirming the nullity of the foreclosure sale and proceedings. 2. Whether the CA erred in deleting the order for Banluta to pay the loan on the ground of material alteration of the PN, which was raised only on appeal. Ruling 1. On the nullity of the foreclosure sale, the Supreme Court held that the RTC and CA's findings on the nullity of the mortgage and foreclosure proceedings were factual and binding as these were not properly challenged by the bank of the appropriate time. Thus, the nullification of the foreclosure sale stood. 2. On the promissory note on material alteration. The court ruled that the issue of material alteration of the PN was not properly raised before the RTC and was only brought up for the first time on appeal. Under procedural rules, issues not raised in the lower court cannot be raised for the first time on appeal. The court found that Banluta admitted the genuineness of his signature on the PN and failed to timely contest its authenticity or raise the issue of material alteration during trial. The evidence established the due execution and authenticity of the PN, and the defense of material alteration was not sufficiently proven. The court further explained that even if there were alterations, Section 124 of the Negotiable Instruments Law provides that a material altered instrument is not avoided as against a party who has assented to the alteration. Since Banluta signed the PN, he is bound by its terms. 3. On the interest rate, the stipulated 20% per annum interest in the PN is valid and binding until the finality of the decision. Thereafter, the legal interest rate of 6% per annum applies until full payment. Dispositive portion. Wherefore, premises considered the petition is party granted. The February 28, 2013 amended decision and the June 25, 2013 resolution of the Court of Appeals in CA-GR CV number 95777 are reversed and set aside. The July 5, 2010 decision of the Regional Trial Court, Branch 69 Iba Zambales, in civil case number 1988-I is affirmed with modifications in that the interest rate stipulated in the September 15, 1999 promissory note shall be imposed up to the date of finality of this decision. From such finality until full satisfaction of the obligation, the total amount due shall earn legal interest at the rate of 6% per annum. Rural Bank of Candelaria Zambales Incorporated versus Banluta Jr. et al. 2022. Key doctrines. Issues not raised in the trial court cannot be raised for the first time on appeal. A party who signs a negotiable instrument is bound by its terms, and material alteration must be timely and properly raised and proven. The stipulated interest rate in a promissory note is valid unless proven unconscionable or illegal, and legal interest applies after finality of judgment.